Good morning. How are you?
Hi, good morning, Odila.
So today with me is attorney associate Monica Rosas with Best and Krieger. I've referred a few clients to Monica, and she's always treated them very well and knows what she's talking about. In this time, I wanted to these uncertain times, I kind of want to talk about estate planning, and who better than to talk about this with me than Monica. So we're going to talk about a little bit about probate, wills, and things that are very relevant in today's times. And Monica, thank you.
Thank you for having me. It's a pleasure to be here. So, what is probate? Probate is the process that a decedent's assets has to go through when there is no estate plan in place. So, probate essentially means a court supervised administration of a deceased person's assets, whereas an estate plan involves a trust, a will, power of attorney, advanced healthcare directive, and any other additional documents that would direct a person's assets and wishes after their death.
So right now for probate, what was it pre-COVID, and what I know the courts are closed. So what are the time frames right now, Monica?
Absolutely. So pre-COVID, we were looking at about an 18 to 24 month administration. However, as you pointed out, courts are closed. And unfortunately, given the uncertain circumstances, we aren't quite sure when courts will be reopening. Therefore, attorneys and individuals alike can't get any filings, can't get any hearings, can't get any court dates on record right now unless it's an emergent situation. And unfortunately, most probate matters do not fall into that emergent category.
So if you had estate planning in place, what is the difference between timeframes with probate and if you had a living trust?
Right. So right now, courts are closed. There is no movement on probate again unless it's an emergent situation. However, in the alternative, if there was an estate plan in place, if a person has a trust, a successor trustee is still able to administer assets, contact financial institutions, sell property, rent out property, whatever they may need to do to marshal a person's assets. They can still do that because the trust administration does not require any court intervention.
Wow.
And trustees are only bound by statutory time limits for noticing, which would be somewhere between 120 days and 180 days, depending on the action, which is obviously much less time than a probate.
Another key point that you mentioned before, Monica, was the privacy issue. Can you touch bases on probate versus living trust?
Absolutely. So a probate, as I've stated, is a court supervised matter, meaning that it is matter of public record. So anybody would be able to look up the court records and pull any of the pleadings or documentation involved with any case. However, in a trust administration, when somebody has an estate plan in place, that trust is not filed anywhere. It is not a matter of public record, making sure that that trust administration remains private.
Okay, so now you've mentioned a few factors that are so important. One is the privacy issue with being on a probate versus non-probate. Another is timeframes. The timeframes are drastically different, and in a situation, maybe 18 months with no COVID is okay for some people, but now you won't even get a hearing until who knows when. So that's another great point. The last point I want to say is we touch bases is the financial impact families have sometimes going through probate that leads them to selling the property because they have no funds to pay the court filings and the attorney fees. So they ultimately have to lose what they had thought that would be their property. Do you want to take basis on that a little bit?
Absolutely. So in a probate matter, the fees for attorneys and personal representatives are set out by statute. That's a sliding scale, meaning that a percentage will be gone in fees plus all of the recording costs that it costs to get the matter heard in court. Now, in trust administration, the person who creates the trust, they have the ability to say they would like a trustee to receive a dollar amount for their work, a percentage for their work. They have the ability to control that.
Whereas in a probate, you're kind of in the mercy of the judge or whoever gets appointed, right? It's a little different then. You don't have any control of that.
Right. So again, the fees are set out by statute. So a judge will go off of just the figures. It's a formula, and whatever the value is, that's the value. A person in a trust, again, can set out an amount certain or a percentage, or can even decline to provide for any sort of trustee fee. It's
Okay.
all about what you decide and put into the trust document that will control.
Now, going back to the privacy and public records, another point that is important that you've mentioned in the past is in courts, they determine who is going to manage your property. And can you touch bases on that? It's a little different, but there is a slight difference and a huge difference if you're it could be even a third party you've mentioned.
Right. So one of the key factors here is that in a trust, the person creating the trust gets to determine all of these things at a time when they are of sound mind and able, meaning that they get to determine who gets to inherit, what they inherit, when they inherit it, and who will be managing everything. So you essentially, as the creator of a trust, get to make all of these decisions ahead of time. However, in a probate matter, there are certain statutes and laws in place that a judge would need to follow to determine who would inherit. And also, it would be up to the court to determine who is best fit to be the personal representative. So, who is best fit to manage all of these assets? Now, that may be a family member, or if there's some sort of contention, that may be a disinterested third party.
Okay.
Right.
Okay. So, lastly, I want to touch on the medical part of the will and the estate planning. If you are now with, people kind of thinking, what if I get sick and I'm in the hospital and I'm in no condition to do a will? Talk to us about how your firm does this for when they do estate planning.
Right. Of course. So, you know, um, it's amazing how people don't really think about putting an estate plan. I think you've come across some research about that.
Yeah, I think it was 80% of millennials right now don't have an estate planning in place. And I thought, wow, that's a huge statistic, 80%. So I thought, what happens if people get sick and now we're in the hospital and don't know how to, we can't do an estate planning then, but I know you mentioned that your firm does some, also not only the quick claims, but also the medical side of it.
Absolutely. So, our firm offers a comprehensive estate plan. So, a lot of times I think that consumers and clients interchange the terms wills and trust. While the two documents actually go hand in hand, they do serve different functions. So, a trust controls the disposition of real property, so your home, for instance, as well as financial accounts. So, you're checking your savings, right? Whereas a will controls the disposition of personal property. So, for instance, jewelry, artwork, vehicles. In addition, in the event that you might have minor children, the will also sets out guardianship. Now, for matters for probate, this is why it's really important to have a trust if you are a homeowner, because in the state of California, any property over $55,425 is subject to court supervision,
Okay.
meaning that if you only had a will, but you also owned real property, that real property would come into probate.
Got it.
So a
So
trust,
the will and the trust go together, hand in hand.
right? But a trust is really the integral point here for homeowners. So for, your clients, it's really important to have a trust. But as I was saying, our firm offers comprehensive estate plans. So we prepare the trust, the will, powers of attorney, and importantly, as you were talking about the healthcare, we also prepare advanced healthcare directives. Now, again, going with the idea of the estate plan, what your healthcare directive does is it allows you to decide in the event that you are incapable, you are incapacitated, you were at the hospital and unable to communicate with your doctor the course of care that you would like. Your advanced healthcare directive has already set out your wishes in terms of pain medication, organ donation, end of life decisions. And we encourage clients, once they have signed their estate plan, that they provide a copy of their advanced healthcare directive to their doctor so that if they are in an emergency situation where they end up in a hospital or something like that, it will be in their chart and the doctor can access that.
Well, thank you so much, Monica. And lastly, I didn't want to take too much of your time, but you have offered to clients, to my clients, as well as whoever views this video, a 30-minute complimentary estate planning consultation. So where can they reach you at, Monica? Do you want to provide your phone number?
Sure. So my office phone number is 858-300-9950. However, if you can't reach me by phone, since of course the pandemic, we're not in the office, please feel free to send me an email, monica.rosas@bbklaw.com.
And we'll have that on the description of this video. Thank you so much.
Thank you.
Be safe. Bye-bye.
Bye.